Hey, Attorney Brian Parker here. Dressed for court? Not really, but generally. Got another video for you today. I've done a number of deficiency judgment repo videos. You can show them up there, Cindy. I think one's defending against a repossession collection lawsuit. Swish. One's fighting deficiency judgments. There it is. Swish. And then there was another one, help before and after the repossession and the protections. And there it is, swish. And I've done a number, and they're all on collectionstoppersolutions.com, along with the important letters and templates and everything you need to defend or go against or protect you before a repossession occurs. So this one today is a little different in that it is creditor-centric. I had a member contact me and said, why don't you do one against Ally Bank? I've got something going. I go, well, it's funny you should say that because I've got something going with them too. I just got a new case with Ally Bank, and you're going to see what I did with them against what appeared to be 100% their side, and we got nothing. So, and when you dig deep, as I always tell you, take the lawsuit, break it apart, and go through paragraph by paragraph, what's false, what's true. Generally, most of it is false. And that goes into your counter affidavit. But I'm going to move on from that. We'll get to that later. So I took a look at the fact scenario, and this is the fact scenario. Client bought a vehicle, let's say 2021, a truck from a Chrysler dealership, and she's making payments, going along. She suddenly had two, not one, but two terminal medical challenges and became homebound and no longer can fully care for herself and is retired and now subsists or survives on a Social Security income. The payment on the vehicle is quite large. When you go, I don't have to tell you, when you go through medical issues, it puts things in priority and perspective. And working hard to make this payment on a vehicle you're not going to use, they send it back. They give it back to a Chrysler dealership. Chrysler dealership takes it and says, we'll get this to Ally Bank. They know they're going to be subject to a deficiency judgment because the vehicle's not worth as much as the loan amount. That's a common thing. So, and then we've talked in the past how when they eventually sell it to obtain as much, they meaning in this case Ally Bank, they will use all the money to pay off the loan. There's usually what's called a deficiency between what is owed and what they sold it for. I've given you videos, again the ones I just showed you, that show you how to protect yourself before they sell it, what you notice you should receive. I've got letters for you that I'll include in Word template with this video on collectionstoppersolutions.com. Like and subscribe and love this video because you're going to. So you now have the fact scenario. The client contacted the law firm for Ally Bank and said, hey, I took out this loan through a Chrysler dealership with Ally Bank. I think the law firm is Brock and Scott. That's a very common thing that's getting into Michigan. They're from down south. And they informed the Brock and Scott law firm that the vehicle is at the Chrysler dealership, told them where it was, what county. And then, of course, what Ally Bank said, oh, you've turned it in? All is forgiven. No, they didn't do that. They sued the client for what's called a claim and delivery. Or in the old days, it was called a Replevin. Some states may still call it Replevin. Claim and delivery really is a repo with an attitude. What do I mean? You know, I've done the videos on what to do with a repo before and after and during a repossession. A claim and delivery is the court being involved. So you have two choices as a lendor to either go repo the thing, where you go on, there it is, there's the car, and you've seen movies. One of my favorite movies called Repo Man, not the new one, the old one. And they run on the property, they jump in and they drive off. And that's generally allowed. A lender can do that as long as they don't cause harm, like cutting off locks to garages or breaching the peace. You don't need a court giving you permission to do that. A claim and delivery is going to a court and saying, we'd like permission to go on the property, to cut the locks, to use the sheriff's office because our collateral is facing severe damages, and that collateral supports the loan. And so the possession, so you look at why does a company do a repo versus a claim and delivery? Well, with a claim and delivery, the pro is you get a court backing you to go on the person's property and breach a peace, essentially, and it's ordering the police to go with you, lender, to go get that vehicle. The minus is you grant the borrower due process. If you sue someone, you're entitled to due process rights. So that's not all, from a lender's viewpoint, that's not always a good thing because they get idiots like me, lenders, borrowers do, to represent them. In this case, that's what the client did. With a repo, the pro, and let's put up the pro and minus, Cindy, of going through claim and delivery. In other words, you're going through court to get an order that says I can come onto the property and also get a money judgment, protect my collateral. Let's put that up, Shazam. That's the pro and the minus. Now with repossession, Cindy put this up. Repossession pro and the minus, Shazam. With repossession, you can go on the property, you can take the vehicle, but you can't make a noise doing it. You can't breach the peace, you can't fight. You can't touch anybody and push them away. Sure, all that stuff is done on a daily basis, and the gray areas are litigated. The minus with a repo is you can't breach the peace like you're kind of allowed to with a court order. There's no real authority. You can't have the cops help you out. Sometimes the cops in a repo situation will kind of help the lender out, and you got to watch for that. You can't break locks, and you can't compel anybody to give the vehicle back. So that's sort of why the yin and the yang, the plus and the minus. Do you go claim and delivery, or do you just go straight up repossession? So why in this case, or any case, does a lender use claim and delivery, which is a statutory, either by statutory action or a court rule? In this case, in Michigan, it's 3.105 MCR, Michigan Court Rule. And it's like that in most states. Most rules are same throughout the nation with nuances, but essentially you're going, hey court, we need our collateral back. In this case, as you recall, my client called up Brock and Scott, the law firm for Ally Bank, and said, hey, the vehicle's been, in this case, the vehicle is in since January. It's been with a Chrysler dealership. We're getting letters from you. What's going on? And they were on full notice, obviously through Ally Bank's agent. I'm pointing over here. For Ally Bank, a dealership is the agent for the Ally, and they represented to my client, hey, we'll get this to Ally Bank. And so there's no, as far as the client is concerned, no dispute that the vehicle is in somebody else's hands. Whereas Brock and Scott in May and June is telling my client, you owe us, we want the vehicle, turn it back. So if the lender, to answer my previous question, why do you use claim and delivery? Because the vehicle is so ensconced or hidden and there's no way to get it, you have to get a court to dig it out of there, as opposed to if you know the guy parks it, like in the movie Repo Man. They were always finding it's on the side of the road or it's in the garage. Well, when it's that obvious, they can go and get it. So you use claim and delivery when you don't know where the vehicle is. As you recall, my clients fully told him where it was. It's in the protection of a dealership. Act accordingly. So what Brock and Scott did in Ally Bank is they sued. So let's look at their lawsuit. Cindy, put up page 3 and page 4 of the lawsuit, and you can look at the defects. Remember I said before, it's a straight up, client owes a ton of money, kept the vehicle, really did an offense. So when you're in that situation, when you feel like that, you break the lawsuit down, the pages and the pleadings. And if you look at number 15, upon information and belief. Now, whenever you see the words information and belief, think in your head, they haven't a bleeping clue what's going on. But you're allowed to say, upon information and belief, somebody's information, somebody, without being specific, you can say anything you want. After you say the words, upon information and belief, you can essentially say anything you want, whether it's true or not. Generally, I'll say it like that. The defendant retains possession of the plaintiff's collateral in derogation of the plaintiff's security. So that's essentially saying they still got it and they're damaging it and we're losing our butts because they're destroying collateral. That's not true. As you heard from the fact scenario, Brock and Scott, Ally Bank's agent, was aware the vehicle's been with somebody else since January of 2024, and now the vehicle is in, now it's July 2024. So they already kind of fudged the truth by saying upon information belief. So they next tell 16, seizure of the motor vehicle and delivery of immediate possession of the same, I'm reading it, to plaintiff, it's up there, to plaintiff is necessary to prevent the depreciation or destruction of the motor vehicle through neglect and improper maintenance. So, in any loan situation, a lender has a right to ask you to don't destroy the very collateral that supports the loan. So they have to allege that to the court, so the court goes, whoa, this is really bad, you get your order. A claim and delivery lawsuit, it's a lawsuit, is filed strictly initially for the purpose of obtaining a quick court order to go break the locks, okay? But they lied in a couple of ways that you're going to see. First of all, let's go this way, okay? Let's show the good folks the wherefore clause, what Ally Bank seeks. Shazam. Wherefore, plaintiff respectfully prays, blah, blah, blah. So the first thing is judgment against the defendant awarding plaintiff possession of the subject vehicle and to immediately deliver the subject vehicle. And then further, order the sheriff and authorized court officer to assist them in getting it. So that's what they want. They want the protections of the sheriff so they can go in and cut locks and do whatever breaching the peace because you got a cop there, which you couldn't do as a repo. And again, that's when the defendant, my client, is hiding or locking up and won't cooperate. Here, the fact scenario is my client told the law firm, come and get it, it's right with one of your guys. So that's a whole plate of wrong. So, and also, hopefully you kept it up. Look at the signature. You always say this, respectfully submitted, July 12th. This communication is from a debt collector. It's an attempt to collect a debt, and any information will be used for that purpose. So under the FDCPA, a creditor is not a debt collector. They're two separate entities, separate from some exceptions. But the law firm has put that on the lawsuit, but the law firm isn't in the lawsuit. So they've made their possible creditor client a debt collector now. So now you can use all the FDCPA. Under 15 USC 1692 E11, that is how to communicate with a debtor. And you always say, we are debt collectors. Anything you say will be used for that purpose. On the last part of the paragraph, I'm going to put it up there for you, Shazam. You can see, except in pleadings. I've explained this before. You never put that on pleadings if you're a lender or a creditor, because then it becomes a communication, and that's a collection communication. Now you've got to give them, the debtor, their validation rights. If you don't, that has consequences. And the creditor has immunity under 1692 GD that specifically says a pleading is not a form of debt collection communication. So the law firm, by sticking that on there, has put their normally creditor client in jeopardy while they're protecting their ass. Excuse me. Those are the consequences of doing that. So now look at the affidavit they attach. Cindy, start at 3, Shazam. And that is an affidavit by the Ally Bank representative in which they say, in this case, the plaintiff is the current holder of the right to recover the subject motor vehicle. Aren't they? It's Ally Bank. Turns out, no. We'll get into that why in a second. Also, that upon information and belief. Now remember, this is an affidavit signed under oath, in which the person signing this, I've looked at the records, it's our job to obtain the records, to have personal knowledge, and we have the right to pursue this. You wouldn't need the words information and belief if that was the case, because that is only there as if you're like kind of fudging and you're not sure, so you put, remember, we put information, belief, then we say what the hell we want. If it's a certified, sworn under oath affidavit, the words information and belief do not belong. Otherwise, you can't sign under oath. And they've called my client a defendant, and they've called themselves a plaintiff, which is not the case on June 17th, because my client was sued in July, I think, 24th. So that, while technical, is not true. And every technicality is magnified when you swear to something under oath. You can't be a little pregnant. You're either pregnant or you're not. You're either swearing under oath that it's all true, or if parts of it aren't, you can't do what he did, is to swear under oath upon information and belief and call my client a defendant when the lawsuit hasn't been filed. And that's doubled down. If you look at number 11, Cindy, I hope that's on the screen. I have read the complaint, says the affiant, to be filed herewith, whatever that is, and all the facts set forth in the complaint are true and accurate and fully incorporate. Well, that's not true, because first the client wasn't a defendant, and it was filed on the 24th of July, a month later. So how could you have read it? I mean, this is the stuff. This is how, from the mouth of victory. So Ally Bank was going to win this, then they step in it. Now remember, Brian's number one rule. What is my number one rule with their documents? Hello? Hello? Eula? That's right, you got it right again. Use their documents against them. So they're having all this supporting documentation to show the court, here's why we should have it, court, and they go overboard because all attorneys are insecure that they haven't done enough for their clients. I feel that way because I want to do more for my clients. Most debt collection cases are where the client doesn't want to lose the account. That's huge. It's this big creditor, big debt collector. So they do more. And they always go overboard to their own detriment. You've heard me say, use their documents against them. They sort of lied under oath here, is my opinion, by calling my client a defendant when they're not, saying I've read the lawsuit to be filed a month before it was actually filed. And now let's look at the main thing that's going to bring them down. I've talked in the past how, again, I just did, how attorneys, they just need to say a couple of things and they say 64 things because there's an insecurity as to what they've got and they need to support it, to support the support. So here, that's a classic case. Cindy, put up there's no such thing what I'm about to tell you. The confirmation of assignment of retail installment sale contract. Shazam. So they put an affidavit, then they're like, in case you didn't listen earlier, here's something else we're creating. When you create something out of thin air, it's called out of whole cloth. That's illegal, out of whole cloth. So they've created this thing that says a deal was made at a dealership where the dealership sold the vehicle to my client and financed through Ally something or another. It's not Ally Bank. The dealership thereafter sold and assigned its interest to the contract to Ally Financial. And then they're calling that a creditor. Then thereafter, creditor subsequently assigned all its right, title, and interest to Ally Bank, also known as Ally Capital Corp., also known as Ally Bank Corp., prior to any default affected as of the date of the contract. Well, there's no date when any of this occurred. There should be 3 assignments attached. They know that. That's why they have confirmation of the assignment. So you break it down for the court. You go, yeah, they say they did this. I don't see the assignment. And then they said they assigned it before it was defaulted. They allege in the complaint that the client defaulted on June 2023 as far as stop making the payments. But they don't date anything. They don't show any of these 3 assignments, which you must show. And there's no proof that this switcheroo with the assignments occurred before the default. You'd have to put specifics for this non-sworn to document to not be hearsay. And then again, you got to always look for this. When they add flowery words, confirmation of assignment of a REIT. In other words, supposedly all this stuff was done, they're saying, and we're now confirming it, signed by Ally Financial, right? Well, at least in Michigan and some states, the party that's claiming they own it now, they're the ones that must sign any assignment. That's not the case here. And also they're saying that all happened a couple of years ago without any specific. It means something. It's total hearsay. So those are the documents we use against lender who had an easy run, could have just got this. The people said, here's the vehicle. You don't need to sue us or anything. There's the vehicle. It's in your agent's hands. So you put all of this in your counter affidavit, which I did. And you can have that counter affidavit. It's beautiful. You can use it in your case. It's attached to the membership website, collectionstoppersolutions.com, with this video. I also gave you the answer in Affirmative Defenses, which once you've done the counter affidavit, jumps into the answer, jumps into the counter affidavit, the Affirmative Defenses. And then when they file that motion for possession to claim and delivery with the court, the quickie motion, you've already got your response. You're not doing anything because the allegation is you're so damaging the collateral, court, we've got to have this right away with police protection and go in there with stormtroopers. If you just say, look, under oath, they have the vehicle, that is not going to get granted. So what's the point? This case is going to get settled because you broke apart and just said, that's not true, that's not true, that's not true. And you have supporting documentation, which is a counter affidavit. So check out those videos. Let's put them up there one more time. Cindy, all 4 videos. They have documents with them on the membership website. This video against Ally Bank will have an answer, Affirmative Defenses, all in Word template, the counter affidavit, everything I did in Word so you can use it, plus my show notes. So you have to look at this face every time. You just read the show notes. And that's it. You've now beaten Ally Bank, hopefully, when they thought they had an easy run of it. And all along, they didn't have to do what they did because the client told them specifically. By the way, when it got down to it, my clients said, like, why are you doing this, Ally Bank, Brock and Scott? They said, with the lawsuit's already filed, now you got to deal with it. And remember, this person is in grave medical harm. Some of it is anxiety-based, and now they're going through this lawsuit. It kind of broke my heart. I really want to work, as I do all my clients, for the client. And I just went deep. I think I spent a whole morning when I could have just done it. And I don't want you doing admit, deny. My heart was in this, so I found everything I used everything I know that I put on these videos and just went in deep for these clients. And you can have all this on Word, in Word, for your own case and go deep. Just follow the instructions and I think you'll do just fine. Like, love, and subscribe. Love, man. Like it, man. Subscribe. And then we can bring you more help when you need it. When the wolf is knocking at the door, bring in Brian Parker's 30 years of fighting back the wolf and use it yourself in your state, your facts, and your rules. Go get them. Thank you very much.